For those who don't know me, I'm Tess Hardy. I'm the Director of the Centre for Employment and Labour Relations Law. And it's wonderful to have so many people in the room tonight to be talking about pure risk prosecution, which is a research concept that Richard Johnstone and I have spoken about. Which we've spoken about over some years now, and it's very exciting to hear him develop those ideas in front of an audience, and an engaged audience at that. I'd like to acknowledge that we are meeting tonight on the lands of the Wurundjeri people of the Kulin Nation, and I pay my respects to their elders past and present. I would also like to acknowledge the support of our sponsors who we're having an advisory board meeting tomorrow evening, so I'll be seeing some of them then. But they make important contributions over many years, but over the last year to hold events like this. So I am very grateful for the sponsors. So I'd like to introduce my speakers for this evening. And Richard will speak for around 30 minutes, and that will be followed by Judge Rozen's comments. So I'm very pleased that he could join us this evening, and then we'll allow some time for questions. And I'll just do a brief introduction to both speakers for those who have not read the flyer. So Professor Richard Johnstone is an honorary professorial fellow at Melbourne Law School. He's a very valued member of the Centre, and his research interests lie in labour law, particularly work health and safety, and he has a long-standing interest in socio-legal research. He has been awarded 6 ARC grants. He's carried out various research consultancies, most recently for the ILO and EU OSHA, and has completed a number of major empirical studies on work health and safety. He has, since 2010, been a Fellow of the Australian Academy of Law, and from 2020 to 2023, he was a member of the Queensland Work Health and Safety Board. And so you'll see in his presentation that he has a focus on the harmonised legislation, and that I think is a reflection of where he's based, which is not in Victoria. And so we are also joined, and I'm really delighted to welcome Judge Peter Rozen, who was previously a teaching fellow at the law school for many years in work health and safety. He was appointed a judge of the County Court in Victoria in 2022, and prior to that, he practiced at the Victorian Bar and was appointed Silk in 2018. He has specialised in work health and safety, industrial and coronial cases. In 2019, he was appointed Senior Counsel assisting the Royal Commission into Aged Care, Quality and Safety, and in 2021 he served as counsel assisting in the St Basil's Nursing Home inquest. So over to you, Richard. Thank you very much, everyone, and I look forward to your questions.
Thank you very much, Chris. I also pay my respects to the Wurundjeri people of the Kulin Nation, and I thank all the organisers, particularly Tess and Claire, who is here with their nephews. Thank you, Claire. And I thank in particular Peter for coming along tonight, and it's good to get the band back together. I've changed the title of my presentation, as you can see on the PowerPoint. Okay. Because as my research unfolded, the issue of the feasibility of pure risk prosecutions came into view just because there were lots of, I began to find pure risk prosecutions in 2023. This project started way before then. This is actually funded by an enforceable undertaking. And I was running 2 years ago by a sister saying, do you want to do a project for an enforceable undertaking on risk-based prosecutions? And I said, no, but I'll do one on pure risk prosecutions. And you'll see in a moment why I make this distinction. But anyway, it's got me to revisit an issue I was very interested in after my PhD in the 1990s, which is the whole issue of bringing prosecutions before any damages. So bringing prosecutions as soon as workers are exposed to risks. And this is because historically, the vast majority of work health and safety prosecutions were initiated in response to an incident resulting in injury or death to a worker or to another person. And the reason that I argue that there was a problem is that as soon as you focus on an event, the event is splintered off from its context. And the context is usually whether there's a safe system of work, whether the employer has a systematic approach to managing work health and safety, they're a bit more radical, you're interested in a way that the event is splintered from the underlying work relations, which some of us argue are very unequal, and production pressures and so on. But once the event is split off from its context, the course is focused on the detail of the event. In particular, after spending many days sitting in court watching this, defence counsel starts focusing on the details of the event. So the defence counsel is able to start blaming other people for what happened in the event, usually the worker in the olden days. It also could be the seller of the plants further up the line and so on. If you focus closely enough on the event, you can argue always that it's particularly unusual what happened. So the more you focus on the detail, the more you say, well, it's really unlucky. And if you put all those three things together, who would have thought? So there's individualization, arguing that everything is a freak accident. And one of the most significant things that happens is that generally by the time the defendant gets to court, they've already pushed the incident into the background because they've already addressed the hazard. They've got a new management team, they've got a new systematic approach to health and safety management, or they've got a new machine. And that explains why work health and safety in a sense is diffused as an issue by prosecution. If we've dealt with the issue, it's been pushed into the past, but nothing really has changed, and also accounts for the low level of penalties. Now, what I've done is because I'm going really quickly through a whole lot of stuff, I've put together a handout which has 4 different things in it. The handout's actually on my desk, so if you don't mind just shipping it around. I completely underestimated how many people would be here because I always assume if you talk about work health and safety that the room's cleared immediately. And clearly it's not, so I'm really grateful to you. So if you could share, but there is stuff there that I will refer to just so that I can keep moving. Okay. Now, why this is, the other thing that I found is that public legal and regulatory discourse around work health and safety prosecutions is often assumed that offenders are to be punished for causing injury and illness. And that is the purpose of prosecution. And I say this because I teach lots of students and I spend all my time trying to get them to think preventatively and not to think about retribution for what's happened previously. So my overall argument is that in a work health and safety regulatory regime that aims to prevent injury, disease and death at work, work health and safety regulators should be willing and able to initiate prosecutions in circumstances where workers and others are exposed to high levels of risk, but before that risk materializes in an incident that causes injury, disease, or death. And secondly, I just want to explore the feasibility of these kinds of prosecutions. For many years, I thought this wasn't possible because I had been told by so many prosecutors and so many inspectors that we just can't prosecute unless there's an inspector. The underlying rationale, of course, is that by conducting more purist prosecutions, regulators will contribute to reframing the discourse and practice around work health and safety regulation, and in particular to emphasise the importance of prevention. And prevention through systematic work health and safety management and through the implementation of safe systems of work, and therefore to ensure that compliance takes place before anything happens. And also there's a second theme about general and specific deterrence, and that's to focus those 2 purposes of sentencing onto the system of work and onto the systems rather than to the incident that takes place afterwards. So the first big question is, what is a pure risk prosecution? So I've defined a purist prosecution as a prosecution that's initiated for a risk-based offence, and I'll come to that in a moment, that occurs in circumstances that have not already resulted in injury, illness, actual contact with a hazard, etc. You can see that I'm fumbling to find a comprehensive definition of harm, and if you've got any ideas about how I can improve that, I'd be very grateful. But I distinguish a purist prosecution from a prosecution for a near miss. I know nothing happens in a near miss, but there has been an incident. I'm just trying to make the point that a purist prosecution should be a prosecution where the circumstances that are extremely dangerous, but nothing has happened, either a near miss or an incident causing injury. So an example of a risk-based offence is the general duties that most of you will be familiar with. Now, general duties are a risk-based offence because the Victorian Court of Appeal has told us that. In the Vibrafile case, axiomatically the court says proof of a breach does not require proof that the breach caused actual harm to any person. The breach consists in the employer's failure to eliminate or reduce the risk to employee health and safety. The occurrence of death or injury or illness is of evidentiary significance only, it is not an element of the offence. And I don't like saying risk-based offences all the time, so I tend to call those inchoate offences. They're offences that occur because work hasn't been made safe, it doesn't matter, nothing's happened yet. And of course, these are to be distinguished from outcome-based offences. And if you want an example, the new crimes of manslaughter are examples of outcome offences. There's offences because they require a fatality. Okay, now I'm going to give an early example of a purist case, and I do it largely because it took place in 1993. I know it's a UK case, but you can't have everything. And the great virtue it has is the judge was a great South African born judge, Justice Stay. And this involved the Science Museum in South Kensington, just near the BMA. Anybody who visits that part of town. I tried to find a photograph that actually had a picture of the cooling tower, but I didn't have any luck, so that's the best I can do. I'm an old dog, these are the new tricks. Work health and safety inspectors found that the Science Museum's air-conditioned cooling tower contained the bacterium that causes Legionella disease. The museum was prosecuted for a breach of the employer's duty to others. And I think it's Section 3 of the Health and Safety Law Code in the UK. And crucially, the prosecution alleged that the air conditioning system had failed to institute and maintain a regime or regular cleaning and disinfection, had failed to maintain an operation efficient chemical water treatment regime, and failed to monitor its efficiency. So the focus is on the air conditioning system. And crucially, the court accepted that members of the public were exposed to risk to their health and safety because of the possibility that the bacterium might escape into the atmosphere outside the museum. So just to unpack that a bit more, the court rejected the submission that the prosecution had to establish an actual danger as distinct from a mere possibility of danger. The court held that the prosecution had to establish that the bacterium was present in the air conditioning system and that there was a risk of it escaping. You didn't have to show that it was present in the atmosphere and was capable of being inhaled. The court held that a person can be exposed to a risk and in breach of a general duty because of their proximity to the risk. Remember, the risk is the possibility of something. In the absence of a finding of any mechanism as to how the risk would come home. And the reason is that this has been accepted in Australian cases. Okay, so now I just want to put as briefly as I can, and I really have to hold myself back, so I'm going to jump quickly through the PowerPoints, just to give you the ethical, pragmatic, policy, and legal justifications for purist prosecution. So I'm just going to pick the best bits of each PowerPoint rather than go through it carefully, but I know you can read, so you'll be ahead of me all the way through. The ethical argument is neatly encapsulated in the International Labour Conference's agreement in June 2022 to amend the 1998 International Declaration of Fundamental Principles and Rights at Work to include the right to a safe and healthy work environment. And if you have a quick look at the rest of the PowerPoint below that statement, you'll see just how robustly health and safety is defined. So it's not simply a case of the absence of disease or infirmity, but it's the state of complete physical, mental, and social health. The pragmatic argument is simply because lots of people get killed at work and suffer injury and illness at work, and it costs a lot. And PowerPoint reinforces and uses billions of dollars. So all that stuff is easily found on the Safe Work Australia website. The policy arguments, I'm drawing on the public health literature here now, and the public health literature talks about primary, secondary, and tertiary prevention. We're not interested in secondary and tertiary prevention. So primary prevention aims to prevent the initiation of disease by controlling exposure to its causes. Or, as the Safe Work Australia website very bluntly states, work health and safety is about preventing workers from being harmed at work. And if you look at the Australian Work Health and Safety Strategy, the most recent one, you can see that it focuses very heavily on primary prevention, and it focuses on primary prevention by embedding good work health and safety practice in all work, across all industries, across all cohorts, and crucially across all hazards. And its goal is also to innovate and deepen knowledge of work health and safety. And the strategy places crucial emphasis on the enforcement of the work health and safety rights. Actions by regulators offer an effective, efficient, and economical intervention for lifting work health and safety practices and should be exercised when necessary. Focus on systematic work health and safety management by regulators will ensure duty holders' compliance in line with the intent of regulation. So, what does prevention entail? As long ago as 1976, I'm not even trying to count how many years it was because I'm bound to get it wrong. Nick Ashford, a very eminent work health and safety academic, reminded us that problems in the work environment are complex and demand a multidisciplinary approach, both long and short term, to be a solution. And most people in the room will be aware of expert technical approaches like occupational hygiene, ergonomics, safety engineering that emphasize the importance of the physical working environment as the primary source of hazards, and focuses on the modification and design of the working environment to remove potential sources of harm. I'm sure that people in the room who, like me, are fans of work sociologists and organisational sociologists who will remind us that the organisation of work is a crucial element of health and safety. And they will make the point very strongly that work organisation, the changes to work organisation, technology and the working environment are far more likely to reduce harm at work than focusing on measures aimed at work. Briefly, just want to remind us that systematic work health and safety management is since the late 1980s, is the approach that best addresses organisational issues. I'm not going to go through that PowerPoint in great detail, but just remember it's a planned and properly resourced and order-seeking approach to ongoing systematic action. Active senior management commitment is crucial. It's about integrating work health and safety into management generally. It's about building work health and safety knowledge and skills. Worker representation, participation, and consultation is crucial, particularly in risk management. And systematic work health and safety management will address change in all its forms, and I've documented behind the change in PowerPoint. And that, crucially, it involves evaluation, and review performance and making improvements. I can see the PowerPoint's backwards in the windows. I can't read it backwards. Now, I just wanted to talk briefly about the regulatory policy perspective. To emphasise primary prevention, work health and safety regulators might make greater use of previous prosecutions to draw the court's attention to the system of work and the approach to systematic work health and safety management taken by the firm, and away from the focus on the incident. This is almost a circular argument. By emphasizing pure risk prosecutions, you have to focus on the system of work and systematic work health and safety management. And that makes it easier to avoid the risk, to avoid focusing on the incident. So I think there's a virtue in focusing on pure risk prosecutions, just to emphasize that you focus on the system of work rather than on the focus on the incident. Now I'm going to dabble in some theory with a very scruffily drawn whiteboard diagram. I argue that if you want to get the benefits of the enforcement agreement, and I haven't got time to go into the nuances in detail of it, you have to bring pure risk prosecutions, because otherwise you can't signal to firms that you're going to go to the top of the pyramid before anything happens. Did everybody see my point? If you only prosecute once events have taken place, you have what I would call a split pyramid, which I've very scruffily drawn there. You can see, and that's an extreme version of the split pyramid. That just assumes that all you do is prosecute and have enforceable undertakings if there's an injury or fatality, and don't do anything other than notice it before that. But the point I'm making is I think if you want the pyramid to work, you have to bring some pure risk prosecutions. Otherwise, the benefits of having a pyramid are just not going to work, because everybody knows you're not going to go to the top until something happens. I also argue that pure risk prosecutions enable regulators to prosecute for all kinds of hazards. There are some hazards that take a long time before the injury or the events manifests, and if you don't have pure risk prosecutions, you'll never prosecute for those issues. And of course, the last point I'm making is that general deterrence strategy focused on pure risk prosecution is crucial for improving prevention. And then, of course, there's a legal perspective. There's a long way of doing this, and there's a short way. I'm going to do it the short way. The short argument is that the legal architecture of the work health and safety frameworks, whether they're in Victoria or anywhere else, institutionalise a primary defensive framework for businesses and so on, requiring everybody to take proactive action to prevent injury or illness at work. The objects of the Act make that very clear. If you look at all of the duties, and I've listed them on the PowerPoint, you'll see that all of them create inchoate offences. For none of them do you have to wait until the injury or the disease takes place. And then very critically, or very pithily, at the bottom, I just said the logic of enforcement, including prosecution, should cohere with the logic of the Work Health and Safety Act. And I've just listed the very few provisions in the Work Health and Safety Act that actually are about incidents, and there are only two. And one of it is incident reporting, which arguably is about prevention anyway, because it's giving you information. And manslaughter is obviously an exception. And then there are some sentencing cases that suggest, because of the provisions of the general sentencing legislation, that the courts can increase penalties because of the seriousness of an injury or death that results from the breach. Those are the general sentencing statutes and the work health and safety statutes. Okay. The feasibility of pure risk prosecutions. I was only able to do this because I suddenly, working my way through all prosecutions in New South Wales and Queensland, began to find them from 2021 onwards. And particularly last year, there was a large number of pure risk prosecutions. So instead of going around and begging to speak to people and asking them whether they think the pure risk prosecution is feasible, all of a sudden you have successful cases. So briefly what I did was comb my way through the publicly available reports of prosecution in New South Wales and Queensland. I pulled out the pure risk prosecutions, and while I was doing, I also calculated the average fines for general duty offences, as one does. And then I did a content analysis of the detailed reports of prosecutions in Queensland in the Magistrates Court, and then I read the 4 district court cases in New South Wales that involve pure risk prosecutions. And what I found was that from 2021 to 23, so that's over 3 years, there were at least 12 furious prosecutions in New South Wales, 4 in the District Court, 8 in the local court, 9 in the Queensland Magistrates Court, and notably, there were 4 in 2021, there were 7 in 2022, and there were 12 in 2023, which suggests that something's going on, and it's occurring in both jurisdictions. Now, my methodology was simply to look at the websites and to look at the cases. So I'd love to talk to regulators and find out what's happening across jurisdictions. A profile of furious prosecutions in New South Wales and Queensland. 12 of the 21 furious cases concern frequently prosecuted hazards, in particular plant and working at height. And anybody who knows anything about work health and safety and has read more than about 20 cases will know that those are things that historically have been prosecuted all the time. And in the PowerPoint I indicate which course the prosecutions took place. So those are the hazards that frequently materialise in injury and harm. And those are prosecutions that usually focus on an accident. It's usually somebody falling off something, or alternatively getting injured in a dangerous machine or forklift or something like that. 5 of the Queensland Magistrates Court cases focus on frequently prosecuted hazards, 4 involving risks of exposure to asbestos, and 1 involving the risk of trench collapsing. So those are things that over the years I've found are sometimes prosecuted, generally not necessarily as general duty offences, but those are prosecuted. And then, very interestingly, 4 of the furious cases involve hazards that hardly ever get prosecuted. And in particular, those exposures to silica dust, and then there's this extraordinary case, the Australia, the ambulance New South Wales ambulance system case, where the district court focused on the adequacy of the ambulance services, systems and processes for handling restricted drugs, which was prosecuted as a furious prosecution. Now, I've listed all of the furious prosecutions in the handout that I've circulated. So if you work your way through near the end, you'll see that 21 of them are all summarised in the
Richard, can I just ask, the ones that went to the district court,
Yep.
Did that resolve to a plea, or did they run before
They
a
were all
jury?
pleas.
Right,
There was only one contested case, I think, by then.
right. Oh, that's interesting.
And that was in the Magistrates Court in Queensland in relation to, I think there was a plant one. Yeah, it's in the details. Yes, and that's the thing, these things hardly ever get contested. So either they're obviously a good idea, or alternatively, maybe not what to do.
Is it possible that some of the plea deals summaries of pleas are what's agreed between the parties?
They all are. Yes. Oh yes. That's why I want to make clear what the methodology is. I'm just looking at cases that were successful, so I don't know what wasn't successful. And I'm just looking at cases from, in the district court cases from the court's perspective. So many of them I don't know how they got there, I don't know how the inspector found out, and I'll talk about them in a moment. And the local court cases, all I've got is a very brief summary. And all I've got in Queensland is quite a detailed summary, but it's a summary, it's not. So that's the limitation. Now, what I've found is that there are signs of tentativeness, as I call it. I've experimented with tenacity, but it sounded weird, so I'm going to call it tentativeness. There seems to be a pattern of prosecuting furious contraventions involving safety issues as Category 2 offences under the harmonised system. So that's an offence where the prosecution alleges that the failure exposes the individual to a risk of death or serious injury or illness, as opposed to a Category 3 prosecution where there isn't that element. So there's nothing about exposure to serious injury illness. And again, that's why I've distributed the handout. I'd probably be category 2 and category 3 prosecution. So safety issues get prosecuted as category 2 offences spanning a single day, which kind of looks like an incident, and health issues are prosecuted as category 3 offences, sometimes spanning days, weeks, or even years. And in one of the cases, it spans 7 years. The breach is alleged to have occurred over 7 years. Can you see what's happening? Can you see that the things that we're comfortable with are the safety issues that get prosecuted as category 2 because we're confident about them, and they focus on a particular day. And there were only 2 exceptions that I've noted in the PowerPoint. Now, in the New South Wales local court prosecutions, the offences were charged either as category 3 offences or as breach of the work health and safety regulations. Right? Well, that's interesting. And the penalty in the New South Wales local court is reduced to 650 penalty units if it's prosecuted in the local court, which is just under $75,000, which is way below the category 3 penalty, maximum penalty in the district court. And it's also notable that the fines for the category 2 prosecutions for contravention of Section 19 duty were generally quite low, apart from 2 cases, the Darlington case and Queensland case number 8. And I've given you at the very last page the average fine for category 2 offences for general duty breaches for corporations, which is the only big enough number of cases to get it. And so you can compare the penalties to those averages. And you'll see that generally the average fines are way below the average fines for all prosecutions. I know that's really crude, this is exploratory, but it seems to be really significant. Now, how do purist cases come to the attention of the work health and safety regulator? They're not incidents, so by definition they don't have to be reported under the incident notification provisions. As I said before, the cases hardly ever tell you how came to the attention of the inspectors. In one of them, the ambulance services in the New South Wales case, the PCBU voluntarily reported their circumstances to the regulator. In the others, the worker must have made a complaint to the inspector for the inspector to have attended. In some of them, the court actually explains that the workers refused to do the work, or other workers said to them, there's no way we should be doing that work, stop work. It doesn't tell you what happened next, but I'm guessing that either there was a complaint to the regulator, or alternatively, the inspector was called in to deal with the stop work issue under Section 89 Section 89 of the Harmonised Legislation. And then there are cases where an inspector was either at the worksite, and the inspection program will run today, it doesn't happen as much as it used to in the old days, and they're generally working at hard cases or plant cases and came across the problem. And there's one extraordinary case which I'll come back to where the inspector was there investigating 2 other incidents and then came across a purist scenario and did a third prosecution. This gives us an amazing case study which will come to later. So anyway, just want to talk about 2 major things, or 3 major things, but 2 in particular. How does the court and the prosecution construct a pure risk prosecution? Now, one of the important things in the story is that from the 1990s, as everybody in the room I'm sure knows, the work health and safety regulators increasingly develop regulations, codes of practice, and national guidance material addressing a wider range of hazards. And that becomes a crucial part of the argument. So it's much easier to focus on the system of work and to explain what reason practical is if you have these various guidance provisions. So I went through all the cases, and for these I could only look at the 4 district court cases in New South Wales and the Queensland summaries, and of course the district court cases in New South. And there were 3 basic approaches that were taken. So the most orthodox and the one you'd expect took place in the Penrose Pine Products case, And that basically used the regulations, the code of practice, and the Australian standard to construct the reasonably practical measures that should have been taken to address violence and the issues that arose on the issue. Okay, that's pretty straightforward, not surprising. In the Extraordinary Ambulance Services of New South Wales decision, guidance was provided by expert bodies that had nothing to do with the work health and safety regulator. So the court was referred to and accepted the National Safety and Quality Health Service Standards, the scheduling of policy framework for medicines and chemicals endorsed by the Australian Health Ministers Advisory Council, the New South Wales Health, Drug and Alcohol Withdrawal Guidelines, etc. And these were all used to show what was reasonably practical in the process of handling restricted medicine drugs. Okay? And then the third case was even more extraordinary, I thought. I mean, bear in mind, I was just blundering completely blindly. In the Dial-A-Dunk decision, what happened was that the inspectors came across this scenario, which I've briefly summarised in the handout, and issued prohibition notices and improvement notices. The defendant then addressed those issues, came up with a system of work that was safe, and then that was used as evidence to show what was reasonably practical. And nothing happened. That of all the cases, that's the closest to an incident. An incident waiting to happen. It didn't happen. And then there was, of course, some cases where there was a combination of those approaches. Usually the first two, usually just using the normal guidance material plus guidance produced by others. How are contraventions investigated? Again, rather than focusing on the incident, sorry, I'm being dreadful. I'm way behind on the PowerPoints. Rather than focusing on the incident, the regulator focused on one or two explanations from that list that I've got in the PowerPoint. Failures to develop a systematic approach to work health and safety management, that was in one case. Failures to have a documented safe system of work in another case. Failures to implement documented procedures, so you have a procedure that set up a good system of work, which you failed to implement. Then that was the case in 3 of the cases. In 5 of the cases, there were failures to comply with the provisions of the work health and safety regulations. And in most of the cases, 9 out of the 13 that I looked at, there were defects in the work health and safety procedures and systems of work. So clearly what's happening is that the guidance material is being used to construct what is really practical, and the courts are focusing either on the implementation of systematic work health and safety management or the system and using these various techniques to do that. Sentencing. There are indications in some of the Queensland cases, which I've noticed on the PowerPoint, which I've now remembered to move, that the courts were inclined to impose lower penalties for offences that didn't result in an injury. So I've given you case 4 and case 1, which the magistrate basically said that. But the interesting one is that case 3 that I referred to earlier, when you had the 3 prosecutions brought together. 2 of them involved very serious injuries, resulting on plant that resulted in lacerations and very serious injuries, and then a third where the risk was just as serious as the other 2, but nothing happened, and in fact both of the workers who were involved in it had been involved in previous incidents, and they refused to work. And then a third worker was exposed to serious injury and stopped work. And then the inspector found out about it because they were inspecting practices. Now just look at their penalties that were imposed. For the 2 that resulted in injury, their fines were $150,000 and $180,000, and for the pure risk offence, the fine was $70,000. And this is brought in the same situation where all 3 offences were before the court at the same time. Now, it's too small to prove anything, but you can see where I'm getting at this. In all but one of the district court in Queensland cases, the courts accepted that general deterrence was a relevant factor in sentencing sentencing and focused on deterrence of other members of the industry. The only case that didn't recommend or didn't have general deterrence as a focus was the Ambulance Service of New South Wales case, and that's because there was only one player in the industry. And there was no point in general deterrence because there was nobody else to deter. In all of the other cases, most of them said that there was no need for specific deterrence because by the time the defendant had come to the court, they'd already remedied all the assets. So, my conclusions, because I'm behind time, I'm not going to go through all the conclusions. I just want to focus on the last point. How can work health and safety regulators find out about pure risk scenarios? The incident reporting provisions don't apply because they're not incidents. Now, in the recent Queensland review of the Work Health and Safety Act, there was a recommendation that the regulator learn or develop ways of gathering evidence of systematic failures to comply by looking at firms that had lots of improvement notices. So if you have lots of improvement notices issued against you, that might be an indication of a systematic failure to comply. My argument would be, why not extend that to prohibition notices as well? Queensland also has a requirement that PCBs report all provision improvement notices issued to them by health and safety representatives. That clearly would be a way for regulators to find out where their firms with high levels of risk. And if you extended that to notifications of situations where health and safety representatives have made directions to stop work, the regulator would have a very nice portfolio of data to focus on some previous prosecutions. And I'd stop there. Thank you.
Hello. Still coming to grips with the idea of the employer called dial a dump, but anyway, I'm sure anyone else has the same concern. I'm going to look at things from a Victorian perspective, playing for hometown audience here, of course. I thought it might just be helpful to set out very briefly the framework of OHS offences in Victoria. Many of you will be very familiar with this, but I thought some of the audience might not. So there's a division in the Victorian prosecution arrangements where all the general duty offences created by the OHS Act in Victoria are indictable. That's been the case in Victoria since 1985. That means they're prosecuted in the county court or the Supreme Court at the discretion of the DPP. In practice, that means the county court. They're very rarely prosecuted in the Supreme Court. But they can all be heard summarily as well by virtue of the provision of the Criminal Procedure Act. And very significantly, there's a major difference in the maximum fine that's available. So if they're prosecuted on indictment in the county court, the maximum fine, as you can see presently, is 1.7 million. But if it's in the magistrate's court, the maximum fine is about 20% of that. 346,000. Now you might, if you know nothing else about the way OHS is prosecuting Victoria, that might lead to certain conclusions. You might think that because 80% of the sentencing power is in the higher court, that you might see maybe something approaching 80% of the prosecutions in the higher court. But in actual fact, it's almost the opposite. So we have the benefit of the Sentencing Advisory Council report. See, Octavian, someone reads them. With data which is quite up to date. You'll see in Richard's paper there's reference to investigations of OHS prosecutions back in the 80s and the 90s, and very similar patterns emerged from this work. So that's looking at prosecutions since 2005 in Victoria. About 90% of cases, don't rely on my maths, but I think that's about right, are heard in the magistrate's court. About 10% are heard in the county court. And of course, that's the reverse, really, of the sentencing power. A little bit more about the cases that are actually heard, and this really links up with what Richard's been talking about. So we can see that the analysis of those 100 or so cases in the county court revealed that 80% of them are cases where death has resulted, 12% are cases where injury has resulted, and there are 8% of cases where there's no death or injury. So 90-odd% are what we might call injury cases rather than the sort of pure risk cases that Richard's talking about. Although you need to be a little bit careful, and you can't just assume that the 8% of cases are in fact pure risk cases. They could be other things like discrimination against employees or failure to comply with notices, and that's especially the case in the magistrates' court, where the figures are slightly different. Well, they're very significantly different in relation to death and injury. So you'll see that it's the injury cases that go to the magistrates' court with a higher proportion overall of no death or injury. But again, be careful about that. Don't assume they're pure risk. They're in fact unlikely to be. They're more likely to be things like discrimination or failure to comply with notices or failure to report incidents, perhaps. That's just sort of guessing from my personal experience of these things. So you can see from that there's a very clear pattern over many years of the way these cases are prosecuted in Victoria, where the prosecuting authorities, WorkSafe and the DPP, are saying really to the world, our more serious cases are the ones where death result. That's why we prosecute them in the higher court where the full sentencing power is available. And the less, what we consider to be the less serious ones where there are injuries only, are primarily prosecuted in the magistrates' court, so they're in that bottom 20% of the sentencing range. Now that's had a very important effect on the way the world at large views what are more serious and less serious OHS cases, and that seems to have not so much to do with the risk exposure, but the outcome. Now, of course, they might be related. I'm not suggesting for a moment that a death case is not necessarily one where there's a high risk, but it doesn't necessarily follow. So it seems to be one way of conceptualising this is going back to Richard's example of the trench. You know, there are rules about about safety in trenches. They're meant to have solid walls and so on. And what would be the normal practice in Victoria, the regulator came across a trench that wasn't aligned with the relevant standards, but it so happened that it hadn't collapsed. That wouldn't be prosecuted at all in all likelihood in Victoria. It would be dealt with administratively by a notice given to the employer, fix the trench, and that's it. It never gets to court. If it happened to collapse and injure someone, then the chances are that prosecution would be in the magistrates' court. But if the collapse led to a death, then that would occur in the county court. So we've got exactly the same risk. But what happens to it in terms of the regulatory response will be determined by the outcome rather than just the risk. And that's made pretty clear by those stats. Now, so the Sentence Advisory Council has produced 2 papers. Anyone interested in this area, I would strongly recommend them because they're really detailed, useful overviews. And you'll see that in the sort of consultation paper that accompanies the statistical paper, focuses on this dilemma essentially, where at the same time as we've got the Court of Appeal constantly saying it's about risk, it's not about outcome, and the seriousness of a given breach is measured by the risk, not the outcome, on the one hand, but then the regulatory practice on the other hand, and also sentencing practice, and I'll come to that in a moment, seems to reflect a different paradigm or worldview. And that's made clear in that second paragraph there. You'll see the Sentence Advisory Council says that notwithstanding that sort of pretty clear legal position, as explained by the Court of Appeal on numerous occasions, the findings in the statistical report clearly highlight the fact that someone died as a result of the offence tends to lead to quite stark increases in the values of the fines imposed. There is therefore a clear inconsistency in the sentencing of OHS offences. The case law seems to suggest that the fact that an OHS offence resulting in a death should play only a very small role in the sentencing exercise, but sentencing practices in both the higher courts and the magistrates' court make patently clear that the fact of the death is a very significant factor, both in the choice of jurisdiction and the fine amount imposed. And of course, they're related because the choice of jurisdiction determines the maximum penalty that can be imposed by the judicial officer. So there's sort of 3 parts to that. And the Sentence Advisory Council concludes that this inconsistency should be rectified they're seeking input from the public about how whether that is right and how it might be rectified. So there's a discussion in the paper, and I'm very conscious of the time, and I want there to be time for questions. So I'll just note that, and taking a cue from Richard, I'll just skip through the PowerPoint slides. That's an English case that's referred to in the paper, which I won't trouble you with. I want to mention a couple of Victorian cases because I think they illustrate some of the points that we're talking about. Bradbury Industrial Services was a case that was decided last year. In the interest of transparency, I was the judge that decided this case. Very sad when you cite your own cases, isn't it? I got lectured by many lecturers here who used to refer to their own books, so it's kind of the same. They can do it, so can I. But this is it's a rare case in the sense it's a hybrid case. So this is a big fire, and in case you're wondering what a solvent processing and recycling facility is, that's must have been autocorrect. That word should be solvent in the first line. Company operated several solvent processing and recycling facilities around Melbourne. They faced one charge under the OHS Act relating to a fire at one of those factories. So a big fire, explosion, one of those ones that happens in the western suburbs in Melbourne from time to time. Anyone who happens to live in the western suburbs knows exactly what I mean. But interestingly, the inspectors investigated the circumstances. They found there was unsafe work practice and it led to this huge fire and explosion. And then they decided to go to each of the other factories that the same company operated to check on their systems for storing their dangerous goods, whether or not they separated the flammable ones from the toxic ones, what sort of fire protection equipment they had, and so on. All of the things that were revealed by the fire, they wanted to check, well, what was the state of affairs elsewhere. And you might think, no, that's a pretty obvious regulatory response. It doesn't always happen because of this focus on the incident. But they did it here, and they found that the problems at the other factories are actually worse. There were greater quantities of dangerous goods. They were stored in ways which were even less safe. And crucially, the fire protection systems at the other factories were worse than the ones where there was the actual fire. So they were prosecuted under the Dangerous Goods Act. Interestingly, they could have been prosecuted under the OHS Act, then they would have fit Richard's description of a pure prosecution. But they prosecuted under the Dangerous Goods Act. So the case came before the county court as a plea of guilty in relation to all of those charges. And so the task then was to assess the seriousness of the breaches, both the OHS Act ones, the maximum penalty was the same, and ultimately I concluded that the fine, I actually think that should be $500,000 there in that second last dot point, and the fines for the Dangerous Goods Act charges, the pure risk ones, were $600,000. So higher fines were imposed for them, essentially because I assessed, just compared the risk rather than looking at the outcome, and I said, well, if there's more chemicals being stored there and the fire protection equipment is worse, then that necessarily means if you're serious about sentencing on the basis of risk, that must make them worse breaches, despite the fact that no one was injured, no one was killed, and so on. So that may be of interest. And then I just wanted to refer you briefly to another case which gets a mention every now and again. It's a rare case in the county court where there was a minor injury, and I say that with the greatest respect to the poor bloke in it who lost the top of his finger. But in the grand scheme of things, OHS, that qualifies as a minor injury. But there were a number of aggravating circumstances in that case. So there was a deliberate decision by the employer to disable a guard on a lathe. There was knowledge at a high level within the organisation. The production manager was aware, he was directing this. Employees were required to work on the machine. There had been previous WorkSafe involvement at the workplace. A WorkSafe inspector would come in. It's almost like an exam question. This is so bizarre. The WorkSafe inspector would come in and say, that's a dangerous machine. You meant to have a guard on it. You meant not to be able to disable it. And they went, okay, yeah, we'll better fix that. And so they fixed it, literally let the WorkSafe inspector leave and then went back to the unsafe way of doing the work, despite having been directed by the regulator by way of a notice. So not surprisingly, the court viewed that as a very serious breach, and the fine that was imposed was about 30% of the maximum at the time, despite the injury being relatively minor. Interestingly, this case started its life in the magistrates' court. As far as the regulator is concerned, this was one of those magistrates' court cases. It was an injury, no one died, and so therefore they thought, we'll prosecute at the magistrates' court. The maximum fine in the magistrates' court at that time, I'm guessing, would have been about $200,000 or something like that. The reason it ended up in the county court was because the defendant refused to consent to summary jurisdiction. So you can't have a matter heard summarily unless the defendant agrees, and the defendant was determined to take it to the county court and to run it in front of a jury, and they were going to win the case and blah, blah, blah. None of that happened, of course. They ended up pleading guilty, thus exposing themselves to the higher maximum, and the court took the view that there was an almost complete disregard for safety. That was on appeal. And the argument on the appeal was that the highest fines ought to be reserved for death cases. So you've got sort of barristers trying to argue cases in line with practice rather than the law, essentially. Which is why I said earlier that the practice of WorkSafe reserving the prosecution, not just WorkSafe, but the DPP, the regulatory authorities in Victoria, prosecuting authorities, running their death cases in the county court, creates this sort of understanding and expectation that they must be the most serious, therefore you'd expect the highest fines to be reserved for them. And interestingly, if you read the Court of Appeal decision in DOTMAR, it's a very clear sort of rejection of that thinking and a further statement that no, it's about the risk, it's about the objective gravity of the breach. And there you are. Thank you.